11. What's a felony or misdemeanor? Can you please tell me? What's a felony? It's a type of crime. What kind of crime is it? Could you please tell me, ma'am? What's a felony?
Like murder.
Right. Serious crimes punishable by a year or more in jail. Murder, kidnapping, bank robbery, murder, manslaughter. Serious crimes go to criminal court. What are misdemeanors? Minor crimes. So if you go eat at a restaurant and you run out without paying for it, that's a misdemeanor called theft of services. And I believe it's punishable by up to 30 days. All those traffic tickets you get are misdemeanors. You don't think of ever going to jail, but you could if you didn't pay your ticket long enough and were bad enough about it. Most people pay it and think it's a civil matter. It's a criminal matter. You need to know this. Why? Because one day you might apply for a job and they're going to ask, have you ever been accused of a crime? Please list. Well, that's pretty stupid because we've all got at least one or two traffic tickets. Those are misdemeanors. They really want to know about your felony. So a felony goes on your record, it's harder, it lasts longer. People tend not to take misdemeanors that seriously. All right. So here's what I want you to do. When I assign you reading, do not read these cases unless I ask you to. So here at the Davis case on page 9, Davis versus BLAW Industries. Look below that, Supreme Court of Washington. All of the cases you read are on appeal, meaning there was a trial, somebody lost, and they appeal to the next higher court up. That's part of our sense of fairness. That if you believe the judge misapplied the law, if you believe the jury was biased or prejudiced or whatever, you can fix it on appeal. All those appellate court decisions are written down. A company called West collects every written decision of every state and federal court in the United States, and they bind them together. Do we have any paralegals or legal assistants here who may do this research? So this creates a uniform citation system. So let's say that it's a case, I find a case in the Supreme Court of Washington. This is number 159 volume of the Washington series, WN, page 413. There's another set of West reporters. It's at 150 Pacific series, page 545. Parentheses means the year of the case. So look to the title to see if it's a civil or criminal case and when it was issued. A civil case might be Miller versus Jones. Jones hit me, I'm mad, I'm suing. What would a criminal case look like? How would it be styled? Yes.
This state.
What?
This state.
State of Texas versus Miller. Remember, every county has a prosecutor who's elected, and if you see Law and Order, it really is true. All the police departments investigate crimes. They put them on the district attorney's desk, and he shuffles through and sees which ones he wants to prosecute. So felonies get prosecuted first. They're sensational, they make the news, they're acts of violence, and the state brings the prosecution on a concept of saving the public, making people feel more comfortable in their homes. It's a crime, a misdemeanor, to not pay for the food in the restaurant. Do any of you worry about that? Would you worry more if you heard 2 people got killed across the street from your house? Of course you would. So crimes that have a priority in prosecution are what tends to get prosecuted first. Violation of Texas Criminal Code, State of Texas versus Charles Miller. So a question on the test might be, I give you a style, is this a civil or criminal case? So for Kennedy, it's likely to be a criminal case. All right. We also look at substantive and procedural law on page 12. What is substantive law? The law of What is murder? What is manslaughter? How do we define the crime? What is kidnapping? All of these things are written down. Substantive law. A lot of you know a lot of law because you watch primetime TV for much of your life. You can't grow up in this country and not watch a lot of cop and lawyer shows. They seem to be so popular on TV. All right, what is procedural law? How do you get there? This is what you really don't know. You go to a lawyer, not just to tell you if you have a good case, but how do I sue? Where do I go? What does my lawsuit have to allege? What does it have to say? What are the rules of evidence? What can I find out about the case before trial? These are procedural laws. So what you see in your life is substantive law. Your attorney knows procedural law. So that's a complicating factor that people don't know much about. You go to law school and you practice. All right. This is what's confusing. Every legislature makes statutes. U.S. Congress makes statutes. Who interprets those statutes? What do those words mean? The federal government says you cannot discriminate against people on the basis of race, religion, color, sex, national origin. What does it mean to discriminate? That just means I wanted something I didn't get, so it must be discrimination. Of course not. I discriminate all the time. How do I discriminate in this class? I give you tests. I discriminate. Some students make an A, some make a B, some make a C. Is that discrimination? Yes. What's the criteria? How you do on the tests? Is there any statute prohibiting discrimination on the basis of giving tests? Really, no. So discrimination is every place. It's the basis for the discrimination. And the courts define what that is. Okay, so appreciate that. The Texas legislature passes laws, and the courts interpret what the laws mean. They're bound by the concept of stare decisis, which is in the textbook, 4 lines from the top on page 8. The decision stands. It's a Latin phrase. Remember what it says in Ecclesiastes in the Bible, there's nothing new under the sun. You don't treat all this as new stuff. You look at prior cases as precedent. And that tells all the courts how to act. Follow this. This case is the one like your case, and you should follow this case. All right? So the easiest example is Plessy versus Ferguson in 1896 is a U.S. Supreme Court case. What does Plessy versus Ferguson hold? What does it stand for?
Separate but equal.
Right, separate can be equal. You had a bunch of Black American plaintiffs who have houses, they pay property taxes. There are a bunch of white homeowning parents, they pay the same property rate. There's no discrimination in who pays more. You have $100,000 value for your house, you pay the exact same dollar amount. The Black plaintiffs allege, though, you created 2 school systems, a white system where the white kids go, and the second system where the Black kids go. And that is a violation of equal protection in the Constitution. You're pushing the Black kids to a separate track school system. Supreme Court says that's fine. Separate can be equal. 1954, 58 years later, in Brown versus Board of Education, what does the Supreme Court say? The exact same case, exact same facts. That is unconstitutional. Separate cannot be equal. So every case from 1896, 1954 followed Plessy. In 54, Supreme Court, which can overturn itself, it's not bound by stare decisis if it doesn't want to be. It says, whoop, the world is different. What changed in society between 1896 and 1954? What's different in 54?
Civil rights.
Civil rights issue, a lot of other civil rights issues, the movement, Du Bois, and lots of other people in the 20s and 30s. Also, the U.S. military desegregated, I think, in the 1940s. Have you ever seen an older movie called Glory? Glory is about an all-Black regiment of soldiers. Yes.
Oh, no, I was just saying that.
Okay, so glory is about the days in the Civil War where you could fight for the U.S. Army, but they put you in a all-black regiment, of course, commanded by all-white officers. The military desegregated in the late 1930s, early 40s. So that's one way society changed dramatically. So before the world looks different. What about Roe versus Wade? What is Roe versus Wade about? It came out in 1973. What did Roe versus Wade stand for? There is a constitution which guarantees you certain rights. Freedom of speech, freedom of the press, freedom of religion. They also said there's an implied right of privacy, which tells the government, keep your hands off my body. And Roe says there's a federal constitutional right to have an abortion through the 24th week of your pregnancy. After that, it's a danger to the mother. But all those state statutes or local statutes prohibiting abortion before the 24th week of the pregnancy are unconstitutional. This is 1973. A few months ago, Supreme Court changed its mind and says there is no federal U.S. constitutional right to have an abortion. You can have an abortion, we don't care, but the states have the power to come into the vacuum, and Texas and other states have prohibited abortion entirely or just for very limited exceptions. So you tell me what changed between 73 and 2022? Yes.
Who was on the Supreme Court?
What's that? Go ahead, sir.
Oh, well, number one, the Supreme Court justice has changed.
Right. Anything else change?
Republican majority,
What's that?
a Republican majority in Supreme Court.
Yeah. What changed? In other words, it's the same U.S. Constitution in 1973 to 2002. It doesn't change. Women's reproductive abilities don't really change. You can convince me that between 1896 and 1954, the society changes because of racial-related issues, desegregation of the military. But what changes between 73 and 2022, I would say just the number of judges on the Supreme Court who think a certain way. So a few people get on the court who are against abortion and they change their vote. It's different people, but the same way. Nothing changes in the arguments. It's just that 5 out of 9 saw it one way in 1973. Another 5 out of another 9 saw it the same way, a different way in 2022. So this is why the Supreme Court is so powerful. It can change its mind. Every other court in America has to follow the decision that turned over Roe versus Wade. Between 73 to 2022, all those cases followed Roe versus Wade. For your information, Wade was the county prosecutor over in Dallas County, very famous. He's the guy that prosecuted Jack Ruby, very famous person. Roe was a female who wanted an abortion. He enforced the Texas statute to prohibit her. She filed a lawsuit, Roe versus Wade, over here in Dallas County. Okay, so that's the value of precedent. All right, who has a copy of Susan is Married? Anybody not have one? I wrote some hard kind of guys. In your computer, look at your computer.
Is it in our textbook?
Just have access to one or the other. No, as you know, you may not have a laptop. Right here. Who needs one? Okay. Look at it. It's a test 1 module on your Canvas page. At the very bottom, the title says Susan is Married.
There it is.
You look on with somebody. Anybody down here? There you go. All right. Here's what's happening. Feel free to look on with somebody. Texas has a self-defense statute. What is self-defense? I'll say it again. What is self-defense? If you are in danger, you're walking out into the parking lot at the mall at 10 o'clock at night, you just saw a movie, someone hopped from behind the bush or behind your car, and there's a gun. You have to sit there and say, shoot me here. No, you have the right to resist and defend yourself. Yes. So it is a defense to a charge of murder. The prosecutor brings the case against you, you're prosecuted for murder. What's your defense? Yeah, I did it, I admit it, but I had a valid reason, self-defense. What makes self-defense valid? Look at the bottom of this, the bottom 4 lines. Here's what Texas says. A person is justified in using force against another when, to the extent the actor reasonably believes the force is immediately necessary to protect the actor against the other's use or attempted use of unlawful force. Are there some vague wiggle words in that list?
Yes.
What do you scratch your head about? Give me the tricky words.
Believe.
Reasonably.
How do you reasonably believe? Okay? What is reasonably believes the force is immediately necessary? Is there a 2-second rule? You have to wait 2 seconds and let them shoot or kill you before you push back. No. So these phrases are written by the legislature with the assumption the courts will interpret. So these cases that you see in our legal system, there may be 100 cases that interpret this statute. Because somebody got prosecuted for murder, someone rose as a defense in self-defense, lost the case, and then appealed to the next court. That I have the right to claim self-defense. All right, what I've done is I posted for you a true life case. This happened in Fort Worth about 10 or 12 years ago. So these are the facts of the case. A woman shoots a guy. This is not like made for TV. She admits she shot him. Why'd she shoot him? She's in the house by herself, hears a noise, walks in the kitchen. There's a guy she's never seen, drunk, walks toward her, curses at her. She takes out a gun and shoots him. The police investigate. They're complete strangers. They've never known each other. This is not a drug deal gone bad. This is just woman had a gun and shot a guy in her kitchen she never seen before. The district attorney knows what her defense is going to be, self-defense. She's going to say, I reasonably believe the force is immediately necessary to protect me against the other's use or threatened unlawful force. She weighs 110 pounds. He's a big bubba, much bigger, much stronger, got tats on his arm and all that stuff. What a female reasonably believed she needed to shoot to kill in those circumstances. So this group over here, get in some little groups. You don't think she has self-defense. Prosecutor, send her to jail. You think she does have self-defense. You're the prosecutor group. What facts support your argument? What facts over here tells you she's got self-defense? Prosecutor, put her in the electric shock, kill her, whatever. She's entitled to assert successfully. So this is what it comes down to. Someone's got to sit in a room and say, look, if you prosecute, there's no suspense. She did it. She admits she did it. But she's going to say self-defense at trial. What is that going to be? How are we going to get around the self-defense? How are we going to assert self-defense? What helps you? Get together in a group right around you. We'll have about 5 to 10 minutes. Make a list. It's all about the facts.
Oh, I'm Alex.
Alex?
Yeah. Ben. That's me, man. All right, I'm not gonna lie. I kind of tuned out.
Yeah,
All I heard was that she was using self-defense against a guy.
it's all good. Yeah, this drunk guy was in the female's kitchen, and I guess she was like, "What the fuck?" And he was like, "Yo, what the fuck?" And then he was going towards her, and then I think she whipped out a gun, pop out, killed his ass.
Oh
And
damn.
then they're trying to find out, like, on
So they're defending the guy who got shot. We're defending the girl who whipped out
Yeah.
the blicky.
yeah,
All right.
that's right.
So, all right, let me see. Well, a lot of it's contextual. First of all, whose house is it? Whose apartment?
It was her house.
It was her house.
We know that for sure.
Okay.
It's her house.
Is the guy a roommate? Is she expecting him there?
She said it was some random guy.
All right, she says it was some random guy,
That's what I'm
but
saying.
why was he there in the first place? Though is like the real question. It's like, is that actually his apartment and she's lying she didn't know, or
Oh,
Bob and Joe are friends
Are
from
friends
high
from high
school.
school.
Bob lives in his house.
Bob is the husband of Susan.
Okay.
So damn, Joe is the home. Damn. She killed the homies. She killed the husband homie.
So Joe knocks on Bob's front door. Let me in, jerk, but Bob never lets him in. John goes back to the patio, stuck. So he walks to the door. He yells, "I am here!" like he's fucking All Might. Joe takes one step into the kitchen. Back patio door appears slightly open. All right, well, see, this is a little difficult. He was intoxicated to the point where it's just like, it wasn't really his fault. So I say it's his fault for getting intoxicated because you have impaired judgment and feelings and stuff. You're not responsible for what happens to you when you're drunk, but you are responsible for what happens after because you chose to get drunk. So I would say, yeah, this is Joe. This is Joe, last name, Mama's fault. Dude. This reminds me of that one meme. Who the fuck are you? Identify yourself. You ever seen that meme? Yeah, I say this is this is on Joe, man. It was his decision.
I mean, that's what we're defending.
Yeah, that is true.
We're defending the
I will say it too. How old is Joe? How old is Joe?
36.
36. No. That's Susan. But how old is
Yeah,
Joe?
she's 36. Oh, Joe.
Whatever. If he's old enough to drink, I assume he has to be at least 21 plus. Because I was also thinking, like, people get drunk, but whether or not it's a decision kind of is, like, debatable. Because, like, if he's going through some shit and he doesn't know how to handle it, then I mean, like, you know, whatever the hell happened to him isn't really his fault. But if he's past a certain age where he can reach out to mental health support, then it still kind of falls back on him. Because he's old enough now to realize he has a choice to either continue substance abuse and doing shit like this or getting himself the help that he needs. Because I'm trying to think about ways that they may defend Joe. And it could be something like, oh, he's going through mental health issues. Well, if he's old enough to drink, he's old enough to understand, you know, we can reach out for necessary mental health support. All right, I'm trying to prepare a defense. He stumbled forward, but I feel like in this report, it doesn't really list Joe's intention. From her perspective, she sees this stumbling drunk inside her apartment. Doesn't know how he got there. Doesn't know what his intentions are.
I mean, either way, it's some random motherfucker in her house. I mean,
I
if
say
it's
give
a
him
friend, but
give
like,
him a
it's-
light punishment. Like, don't send. Maybe I don't know. Put him on house arrest. I say don't send him to jail. Put him on house arrest because he didn't have any weapons. From his side of the story, he wasn't there to like do any harm. She was in her rights to self-defense, and he is to be held accountable for his actions to a certain punishment, only enough for like the punishment that for the crime he committed. You know, he wasn't supposed to be there. He shouldn't have been drunk. Put him on house arrest. Make him, you know, I guess find a way to like pay his bill, house bills, hospital bills, whatever. But she was within rights to use her self-defense because she didn't know his intentions
Yeah, that's right.
from her perspective. However, from his perspective, you know, he didn't have any weapons. Doesn't seem like he had anything like bad intentions going on. I say that's fair. Put him on house arrest. Yeah. We need like a lie detector. Like each of these things. These people can't be held to be like integrity.
Could you prosecute this woman? Or would you identify with her?
But I also understand from, I guess, his point, since he was unarmed.
But my question is you as a representative female, could you zealously, forcefully try to prosecute her and convict her of murder? You could not. Then you wouldn't be a good prosecuting attorney. You wouldn't know if you feel a little bit strange about that. No, the inclination is they're good for the grace of God to go on. But if you're a woman prosecutor, that's what your boss is going to say do. Give her 30 years, prosecute her. So that's the first issue. Attorneys take the cases as they are. They take the facts, they take the law, and the prosecutor, you're not supposed to regard what may be your personal feeling. Many women would say, they're put for the grace of God, it could be me, I couldn't zealously prosecute. So that's the first issue, makes it a little bit different for women. All right, but now we'll pretend we're prosecuting. What are the facts that help your case? Please, ma'am. Let's put them up here on the board if I can find them. There we go. So we'll say prosecute. What are the facts? There's no self-defense. Give me good facts. What's that? Okay. So how does that prosecute? Her fault. I'm on the board about that. I'm going to put door open. I'm going to write I think that's a pretty hard standard to say. Okay. All right, number two, what's the fact of prosecutor? Yes, ma'am.
He has nothing in his hands.
Unarmed. So he's clearly unarmed. He ain't got no gun, he ain't got a knife, he's just unarmed, and she knows it. He's not like this, he's like this. What else?
He was drunk and he feels something.
Right. So he's moving closer. When did you see him? How far is he away? 10 feet. When she shoots him, where is he?
6.
So he's moving forward in some drunken form. So he has alcohol, which maybe means his judgment's impaired. A lot of times you stay clear of people who've been drinking too much because they might, get violent or something. He's moving closer. What else is a good fact to prosecute? Where is she? Where was she? She's in where? No, when she first hears this noise, what does she do? She's in her bedroom, presumably sleeping. How did she get to the kitchen? She went by what? The hallway, the living room, the front door, went into the kitchen, and so forth. She ran from this side of the house to the other. She's a hot-headed hussy. So instead of running, couldn't she have hidden in the bathtub and pulled the shower curtain? I told you she ran past the front door. Couldn't she have done that? Couldn't she? What did she have to do? How long did the police get there? Okay. Couldn't she have hidden? Couldn't she have fled? Why didn't she?
She was angry.
Here's her chance to get back at all this bad boyfriend in her life. Hot dog, I got a live one here. She runs in there, cuts on the line, find your dead. She's hot-headed. She could have prevented this. All she had to do was stall for 4 minutes. What else? Yes? What's that? Right. She knew the cops are on the way. You're exactly right. Not only did she run to action, the cops were there in 5 minutes. 4 minutes. Couldn't she lock the bathroom, pull the shower curtain, and get down like that, and just not make any noise?
Oh man, she said no word.
Or ran out the front door, or broke in the window in the bedroom, whatever. Yes. She didn't say anything. Okay. So she basically cut on the kitchen. He said, "Who are you, bitch?" And she shot. So she didn't give a warning. No warning. She just shot. Anything else?
I mean, if he said, "Who are you, bitch?" pretty much basically, then he didn't know where he was at. He could have thought he was in his house.
But I'm trying to prosecute her.
Exactly.
Right, so she
pretty much
sees a.
basically-
What does he have on his arms?
Cats.
That's your. So do you see how the facts play out? I gave you a lot of facts. Gee, it's kind of boring, Mr. Miller. But everything goes by the facts. The door is open. Her damn fault. He's unarmed. She got a gun. Alcohol on his breath. You know what it does to your judgment. Moving closer to him. Saw him at 10 feet. Shoots him at 6 feet. She ran to the kitchen. All she had to do was stall for 4 minutes. Cops are coming in 4 minutes. Shot him without a warning. She's hot-headed. And we want to keep people like that from doing it again. Because she might shoot the next guy who's in her house. All right. So those are the ways the prosecutor would argue to her. Fatal injury, unarmed man, et cetera, et cetera. Now, yes, sir.
What about excessive use of force?
Let's get to that in a second. Just 1 second. Okay. Oh, okay, that's the question then. Reasonable force. What does the statute say? You can only use reasonable, the degree the actor using force against another when the degree the actor reasonably believes is necessary. The hell is shooting an unarmed man? Is that by definition beyond reasonable? Okay, that's one argument. So let's say that number A is excessive. That you can only use reasonable force, and that's not. All right, over here, what are the arguments to self-defense? Yes.
Well, you said the alcohol can change people's judgment, so you never know how the alcohol could make his judgment.
Okay, so it might have been hopelessly drunk. You can't even stand up. So most people go from violent or active to sleepy to falling down on the floor and can't get up. At least that's been my experience. Okay, so we'll say maybe he's excessive. Maybe he's rendered harmless because he's had too much to drink. Number 2, what's a good argument for self-defense? What's that now?
It's her house.
Her house. Is he trespassing?
Yes.
What else?
He was,
Abusive,
What's that?
abusive. Abusive.
What profanity?
Abusive.
he was yelling.
Okay, yelling. So, does that make him more? Plus, he has tattoos on his arm. In my generation, okay, I'm so old. In my generation, if you had tattoos, that meant you were a biker or a pirate. In your generation, I don't even want to know.
A pirate
I
biker.
don't even want to know how many you have tattooed. Please don't tell me. But he's got cats. How much bigger is he?
6 feet.
He's out.
What's that?
6 feet.
6 foot.
What is she? So let's say 6 inches, 7 inches on. How many pounds?
190. 190.
Oh, so
She's
7
got 70 pounds.
and 7 inches. He's a big guy. No matter how drunk he is, he's still drunk. She don't have time to give him a breathalyzer and figure how much. Yes.
This is a little bit of an odd one, but because she teaches that, like the rape aggression
Right.
course, she also knows what people can do to each other, even if they're not armed.
Right.
She knows how much of a risk something.
Do they teach rape aggression defense at UTA? It's a self-defense course taught on many college campuses for women. If you're accosted by somebody, it doesn't tell you how to stop it. It tells you how to really hurt them. Claw their eyes out, burst their eardrums, maim them for life. So it's very, she knows rad. Plus she does CrossFit. She's in a lot better shape than the average female is. And she did nothing. Didn't warn him. No warning. So, self-defense. She had those things in self-defense. Yes.
He started moving closer to her.
Closer, yes, closer. So do you see where I'm going with this? You pile on the facts. Yes.
So I know you said like she's a hot-headed, but you could also argue that's adrenaline. When you're
Right.
in danger, it's fight or flight.
But, so can the same set of facts be subjected to two different interpretations? I would say yes. Usually you're afraid, and then you get really afraid, and sometimes you just do crazy stuff. Your adrenaline kicks in, like you say, yes.
I don't know if this was covered earlier or not, but also just the language he's using. If he said like, "Who are you?" and it seemed more questioning,
Right.
that would mean maybe he's drunk and confused. But if
Right.
somebody walks into my house and is just like, "Who are you, you son of a bitch?"
Yeah.
I'm gonna think that applies aggression.
Right. Also, where did she first hear him knocking on the front door, yelling? Then he reappeared on the back door. Would that suggest to a reasonable female he's really trying hard to get in the house? Does it matter at 1 a.m. or 1 p.m.? It's right. Yes, it does. Do good people walk into your house at
In
1
broad
a.m.?
daylight. No.
Probably not at 1 p.m., but I give them a little bit more of a break. But after midnight or 11, it just gets kind of creepy when people appear in your house. So the question, the prosecutor, the self-defense is going to say, look, yes, sir.
Well, isn't there like a penal code that says like you're allowed to use deadly force to protect your property?
I'll get to that in a second. Okay, this is what I gave you. This is the self-defense statute. So self-defense is that he's drunk, he's 70 pounds heavier, 7 pounds taller, he's a trespasser at 1 a.m. on a bad night, nice people don't walk into your house, he's run from the front to the back, he's cursing, he's yelling, and all these things. She could have used rape aggression defense, but she didn't. So how do you think this case comes out? Here's the way this, it's just like law and order is actually right on one thing. The police investigate the crimes in Mansfield, in Arlington. Every file gets sent to downtown Fort Worth, where the Tarrant County prosecutor is, and he's got this many files. He's got 10 attorneys, 20 junior attorneys, 8 paralegals, 4 investigators. I've only got so many resources. He picks the cases out of the pile he wants to prosecute, and he wants to get a conviction. So the question is, if this is on your file, would you take this case? You already know the facts. It ain't a whodunit. Would you prosecute or would you not prosecute? What do you think? What would you do, ma'am? You're the district attorney. What would you do? Would you prosecute her with confidence that you could convict her? Please, ma'am. Yes.
Oh, me?
Yes.
Oh.
Yeah.
I would,
What would you do?
I would prosecute.
You would prosecute? Okay. How many would prosecute? How many would say self-defense? Okay. They did not prosecute. Because it's perfectly well known everything she's going to say. So how many people on the jury or the judge have a wife, a mother, or a daughter who might be at home at 1 a.m., hears someone knocking on the front door, runs to the back door, sees a drunk guy 70 pounds heavier, 7 inches shorter, walking at her cursing? Would a reasonable female defend herself? I believe so. Okay. Yes.
Could you tell us what the attorney and the defense and the prosecutors actually did in court to?
No, it never got to court. In other words, literally, the prosecutor has 100 cases to go. He got rapes in Arlington, bank robberies in Colleyville, sexual assaults in Fort Worth. Which am I going to prosecute? And he passed on this case. It never even got to trial. Why? Because he's not going to win. The average person, there's somewhere out there, every place there's a male with a sister, a daughter, a mother, a grandmother who's going to identify with, oh my God, what if it been Aunt Susie at 1 a.m. with the drunk guy in the kitchen, coming toward her, cursing at her? Should she be prosecuted and given murder? Hell no, that's self-defense. All right. Now, I didn't give you all the information. Another reason was Texas says, look, there are 3 places you can more or less do what you want to. And the 3 places are your home and your office and your car. In that case, the burden of proof is assumed that you've met it. The assumption is that someone's in your house, you can use reasonable force to get them out if they're trespassing. Okay? Your office or your car. So it's harder to prosecute, very difficult to prosecute people. They say self-defense, they prove it, and that's it. Very hard for the state. The presumption is it's valid. So what do I tell students? You're in downtown Dallas, some guy comes into your car with a gun or anything. Before you shoot him, put him in the car and shoot him. Or if you shoot him outside, pull him into the car. When he's got to be in the car, we can find the body. What does it mean in the house? Does that mean he's in the garage stealing my bicycle? No, he's in the house. And let's go back to your issue. This is a death case. What if you saw a guy in your kitchen turning around, walking out with your kid's tricycle? Would it be reasonable to shoot it in the back? No. I would say no. Is there a different standard for defending you or you and your property? Is defending me or defending my date in the parking lot at night when the mugger is there, do you have more wiggle room to be reasonable than if you're defending your bicycle? Of course you do. We had a great case in law school. There's a farmer, chickens are getting stolen. He knows how to stop the chicken thief. He gets a 12-gauge shotgun. He spring wires into the front door of the coop at 2 a.m. Kabam! And a chicken thief has opened the door and had his head taken off by a 12-gauge shotgun blast. What's his defense? Reasonable force. What did the judge say? Not reasonable. You're defending a chicken. Is the chicken worth more protecting? No, than human life. All right. So this is how the case is. This is great stuff. Texas has the castle doctrine. Your home's your castle. Your house is your castle. Your office is your castle. What about Trayvon Martin? Who is Trayvon Martin? Yes.
He was, wasn't he like a teenager walking?
He's a teenage Black American kid. He's walking someplace. A guy named George Zimmerman has a license, valid permit to carry a gun. Something happens between Trayvon Martin and George Zimmerman, and George Zimmerman shoots him and kills him. He's subsequently prosecuted. His defense is self-defense. It's a tough case. It was a big case at the time. There's one weird thing. Florida has a weird statute called Stand Your Ground. Stand your ground means you ain't got to do nothing. What's the best argument against her? She should have fled. She should have hid. She should have run out the front door. In Florida, you don't have to do nothing. You stand your ground, whip out that gun, and blow away. So complicating the Trayvon Martin case is that Florida has the most generous pro self-defense law there is, which is you ain't got to run, you ain't got to flee, you ain't got to wait till the police get there. You can stand your ground and shoot. Yes.
So you were talking about your house. Does that apply to like your property as well? Say you see
No,
somebody.
just your house.
Just your house, guy.
Right. Remember my example. If the guy gets outside, in this case, the facts are different. He turns around, he runs outside. She's outraged. He was in her house. He should shoot him while he flees into her yard. No, that's not self-defense. In my own case, what happened is my wife and I were at dinner one night at a neighbor's house. We hear a bing noise. Sounds like a bullet. We look out the front yard. There are 15 police cars. Holy cow, what happened? It's a very famous case. There's a Mansfield off-duty policeman going home off the shift in a civilian clothes. He sees a wreck in downtown Fort Worth, and the other car flies away. They leave the scene of the crime. So he chases that car to stop the guy from fleeing the scene of the accident, which is a separate offense. No matter who's involved. This guy is coming on our street. He stops. He sees this strange guy following him. He has no idea he's a policeman. He hops out to say, "What the hell are you doing following me?" The Mansfield policeman hops out and says, "I think I saw a gun." Bang, he shoots. And the guy falls down dead in the yard next to ours. So they put the Mansfield policeman on an indictment, or we're going to prosecute, and the jury says no. I think you have a gun. Bang. They never found the gun. There were literally 15 police cars there crawling on their knees trying to find the gun. They never found it. Well, I thought he had a gun. Bang, you're dead. What's his justification? He was drawing, it was self-defense. So you apply these laws under different sets of facts. There's no racial issue here. It's a white guy that's shot dead by another white policeman. This is not a George Floyd who gets treated differently. Same race, same gender. One guy's dead because I thought he had a gun. So this is just how this stuff applies. Okay, what determines it? The precedent of the law. What have Texas courts said in the past about reasonable? So somewhere there's a lawyer who's got a database. He just types in Texas self-defense and reasonably believe, and all the cases pop up. This is legal research. This is what attorneys do. This is what you don't see on primetime TV. They're great-looking guys. They're great-looking girls. There's drama in the courtroom. They're brilliant. God, I want to be like that when I grow up. The real practice of law is someone sitting in a library at 9 o'clock at night reading 28 Texas cases which interpret what reasonably believes. So it's different in the practice world than it is on TV. That's all I'm trying to say. I think you kind of know that, but when I watch those top shows and lawyer shows, I just laugh. This shows you starting the cycle. The prosecuting attorney knows in all the cases that have come out in Texas interpreting self-defense, every one of those cases that helps her, there are more of those that help us. We ain't going to prosecute. And then toss in the fact that there was also the Castle doctrine at the time, and he's dead lying in the kitchen where he got shot. The prosecutor says forget it. So that's how these cases work. Research, value of precedent. If the law had been the other way, the prosecutor would have prosecuted. But you predict the law because you know that prior law interpreting the self-defense statute is going to be shoved in your face, and you ain't going to react. They've got 21 cases saying yes, you've got 3 saying no. We're not going to waste our time trying to prosecute. Okay, that's how your legal system works. Okay, so if any of you going to law school, understand it's not quite all Armani suits and Victoria's Secret models. Someone sits in an office and does legal research on the computer and finds those cases interpreting that statute and cites those cases as precedent because they help the client. Okay, now we go to the court system. Who creates the Texas court system? The Texas legislature. Every state has its own judicial code, creates its own court system. The Texas legislature creates the Texas criminal code. What's a crime? It also creates a Texas judicial system. Might be different in New York or Florida, but we're going to focus on Texas. Most of the stuff is not in the book. Let's start off with state judges. How do you get to be a judge in Texas? Are you elected or are you appointed? The general rule is you are elected. So you're elected, why? What's that? Right. The people in their wisdom say, Bubba would be a good criminal court judge. So Bubba gets elected, and Texas does it the worst way possible. In Texas, you run as a Democrat or as a Republican. We have partisan political races for judge. In some states, you have to run and you can affiliate with a party. Here, some people just pull the lever and vote all Democrat. Don't give a damn if they're good or bad. They just like Democrats. Some people do the same thing for Republicans. So it's kind of creepy to think that one person pulls the lever, elects only Democrats, be all the judges in Henry County. I bet you there's a good Republican out there too, or vice versa. Yes.
This is kind of an off-topic question, but I was going to ask why you use the name Bubba. It's just a random name.
It's just a random guy.
Oh, okay.
Is it offensive to anybody?
No.
No, in the
Bubba's just the stereotype Texas guy who has to pick up and wears jeans.
Yeah, there's a guy like that in the county I'm from.
Yeah,
That's
yeah.
why I was
Bubba's
asking.
just yeah, no offense. I call it Tommy, I just pick Bubba. Okay. How do you get to be a judge? Look at Exhibit 2.1 on page 22. Merit selection by nominating commission. In some states, the governor appoints the judges. He has a committee of distinguished lawyers, and they say, we think that Charles Miller would be a good judge. I'll appoint him again. So in some states, it's called merit selection. What really happens is you got to be good, and hopefully you support him. So you're a Democrat, he's a Democrat, you like Democrats, yeah, I'll pick that guy. The next one is governor or legislature appoints, same thing. Election by party, that's where Texas is in that list. So Texas has elections to serve a 4-year term. You've elected a judge, you serve 4 years. Can you run again? Of course you can. So as long as you can get reelected, you can serve as a judge. In Texas, all judges have 4-year terms. That's how it works. Some states, most states have nonpartisan. You run as you, but you can't identify as Democrat or Republican. Texas does it the worst way. You run as a Democrat or Republican. And there's a lot of straight ticket voting, which undermines the concept of getting the best people on the bench, be they Democrats or Republicans. Finally, on the far side, combined election of appointment and merit. The point is, they're appointed by somebody or they're elected on the road. You got to run as a Democrat or Republican in Texas. There's some sleazy sides to Texas. One of the sleazy sides is, if I'm going to be reelected in 2 years, I've got 2 years to go, what do I need to run for reelection? Starts with M. Money. Okay. Money. That's good. Okay. Who might give me that money? Okay. Attorneys who practice before me in my court. They might give me $1,000 because the next time I'm in the court, they'll like the people who give them money. So the judicial process is undermined by the fact that if you're an attorney, you are constantly asked to donate money to campaigns of people who want to be judges. And that's a very frustrating thing. So that's the process. Some other downsides to the process are who you're going to get, good or bad. Would a merit appointment process by the legislature or governor would be better. You'll never know in Texas because the judges like the system the way it is. If I run for re-election, it may cost $100,000. I can shake down lawyers for 50 or 60 of that. And if you're in practice every week, you get invited to $100 a plate dinners or parties to bring a check. That's how our system works. Then the issue is, what if you're really bad? Can they get rid of you? Not really. You guys know who the affluenza guy was? It's a guy that has a car, drunk, kills 3 women, 4 women. His defense was he didn't have a sense of right and wrong. He's always lived in an economic bubble. He's a rich kid. He's always been a rich kid. He ain't got a sense of right and wrong. And the judge decided in his favor and let him off or gave him 2 years. People are angry, and the judge ran for re-election. So a lot of people try to raise money against the judge because they think she gave a 2-year sentence, which is outrageous. They love it. Some states you can recall a judge. In other words, you have an election. So what if you're a judge and there's a sexual assault case and a woman is raped by someone and the judge says, tisk, 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 we'll give him a couple of years. Is that too light? Let's recall him. Let's not wait for the 4 years to expire. Let's sign a petition. A lot of people want to have an election. The public authorities hold an election. People turn out and remove him from the bench. Not because he did anything wrong, but because people didn't like his too lenient decision. I'll post a case for you out of California where that happened. So state court judges are elected on state rules. They serve 4-year terms in Texas. Texas does it, I think, the worst possible way, partisan, i.e. run as a Democrat, run as a Republican election. There's one good thing about being a judge. You cannot be sued for what you did. What if I say that the plaintiff should win the case? The defendant appeals and overturns the decision. I made the wrong decision. Can the other side sue me for being stupid? No, I'm immune from lawsuit. Remember how you get a shot, you have immunity, you can't get that disease. Exact same thing about conditional immunity. The judge should not be intimidated into finding from somebody for fear they'll be sued. Judge should be able to do as he thinks best, no matter how he's on the bench, elected or appointed. So judicial immunity means you can't be sued for what you do. I'm a judge. I'm headed downtown to Fort Worth for the courthouse. I have a car wreck on Interstate 30. Can the other driver sue? Yes, why? I've got immunity.
Not in that case.
What's that?
So that would only mean inside the court.
Right, it's not inside the court. Immunity simply means for what you do as a judge. When you're on Interstate 30, going 70 miles an hour, you're just another guy on the Interstate 30. You can't claim, you can't sue me because I'm a judge. No, it's only what you do as a judge that makes you immune. So think about it. Judges shouldn't be forced to worry who might sue them if they decide for the other person. The richest guy in town has the most lawyers. I'm not going to fight against him. I'm not worried about poor people. Screw them. They ain't going to sue me. Okay, so just understand that immunity provides a very good principle in state court judges. So very quickly, we're going to talk about how is the Texas court system created. We'll get started on this. How many of you have ever been in court before? Here's some problems out there. Okay, there's a stop sign up here that I hate, right near the athletic center, the business school. I've run it God knows how many times. What ticket do I get? Where do I have to be? City of Arlington Municipal Court. It's a small court. It's the nearest thing that you and I know to a small claims court. The mayor appoints the judge. You get set for a ticket. What happens is they give you a ticket and tell you to appear. They make it as inconvenient as possible. Would you like to go to the Arlington City Court at 3 o'clock on Friday afternoon and pay your ticket or enter a plea of not guilty? Most people say, screw it, here's the $200. But you can fight it if you want to, you make that decision. they give you a date for a trial, and you go to trial. Nothing's at stake but $200 ticket or whatever. Okay, so it's a very little court with very little power. They're used to deal with traffic tickets. Some people call it the traffic ticket court, people call it city court, they call themselves the municipal court. What's a code compliance issue? How do you maintain your property? City of Arlington has a code that says you gotta cut your grass. If your grass gets over 18 inches and we warn you and you don't cut it, we'll cut it for you. That's the good news. The bad news is we'll charge you $800 for a yard this size. You get your ticket and you gotta go to court. So traffic ticket, code compliance cases go to city court. So that's the city court. What's the only way I know to get a traffic ticket? What's that? Or what? Yeah, ask for a trial date and hopefully they'll set it for trial and the officer won't show up. In most cases, to prove you did it, the officer out here has to say, I know his name, Mr. Finley. He has to say, I was there, I saw you run the red light. What if he's in a training program that day? What if he's at home with COVID? He doesn't appear and the judge dismisses your ticket. So I tell students all the time, the chances you're going to show up and dazzle the judge with your brilliance is less than 1 in 1,000. They've heard it all before. But I appeared one time that morning, the judge is there, the city attorney is there, the policeman never shows up, the ticket gets dismissed, I never heard of it again. That's the only way I know. So don't ask me, how can I be the traffic ticket? Set for a trial and make it hard for them. Who the hell really wants to be there? It ain't you. Officer Finley's too busy to give a ticket out here by the UVA bookstore. Yes,
Sir, is there some things that you can't sit a trial for?
yes. So they give you this. They give you the option. You want judge trial or jury trial?
Judge trial.
Yeah. So you get to pick. The jury trial is more inconvenient for the city. They've got to summon people to the jury duty. You got to pick the 6. It's more complicated. Make it hard for them. Ask for a jury trial. Please no guilty. Ask for a jury trial. That inconveniences the most people. That's the way to keep it going. Okay, I will sign you a reading. I will see you Monday.